My name is Jeff Morgan. I'm from Dallas, Texas. In the Texas Family Code in section 153.009, it pertains to interview of child in chambers. And point A says this: in a non-jury trial or at a hearing on the application of a party, the amicus attorney, or the attorney ad litem for the child, the court shall, not may, the court shall interview in chambers a child 12 years of age or older to determine the child's wishes as to conservatorship or as to the person who shall have the exclusive right to determine the child's primary residence. The court may also interview a child in chambers on the court's own motion for a purpose specified by the subsection. B says this: in a non-jury trial or at a hearing on the application of a party, the amicus attorney, or the attorney ad litem for the child, or on the court's own motion, the court may interview a child in chambers to determine the child's wishes as to possession, access, or any other issue in the suit affecting the parent-child relationship. The next point says this: in interviewing a child does not diminish the discretion of the court in determining the best interest of the child. So the best interest of the child is a whole nother topic in itself. Nobody knows what the best interest of the child is. Really, the way this should read is that interviewing a child does not diminish the guess of the court in trying to figure out what might be the best interest of the child. The best interest of the child has no definition in the Texas Family Code. There was an opinion issued by Attorney General Ken Paxton this year, and he talked about 8 factors that go into determining what they might guess to perceive to be the best interest of the child. But the best interest of the child has absolutely no objective standard. And again, I will talk about this in another video. Then we talk about point D, it's a jury trial. This was not a jury trial, so I'm not going to talk about that. E, in any trial or hearing, the court may permit the attorney for a party, the amicus attorney, the guardian ad litem for the child, or the attorney ad litem for the child to be present at the interview. So this again is pertaining to an interview in the judge's chamber. F, on the motion of a party, the amicus attorney or the attorney ad litem for the child, or on the court's own motion, the court shall cause a record of the interview to be made when the child is 12 years of age or older. A record of the interview shall be part of the record of the case. Several days ago, I was at a hearing that I thought was probably the most abusive hearing that I've seen. Now, I've gotten into hearings with people, friends, just to see what exactly takes place, because no matter how they describe what takes place in these family courts, it does not even come close to approaching the horror that takes place, the abuse that takes place when you witness it firsthand. And I'm not saying about every single case, because maybe there are some good cases, but the ones that I have seen, I have just been appalled over the lack of justice, the miscarriage of justice, and in many instances, the abusiveness of the judge toward one of the litigants, and also the lying and the chicanery and the extent an attorney will go to conceal the truth. Not to reveal the truth, to conceal the truth. Any truth that is damning to his or her client needs to be concealed. So there's really no way to determine the best interest of the child if you're dealing with lies to begin with. So in this hearing that I was just at, the opposing attorney would only permit a yes or a no answer, and I understand that. They ask questions in such a way that yes or no, but yes or no does not really capture the truth, as everybody knows. Yes or no gives a soundbite to the attorney, because the attorney is there to tell a story, to persuade the judge with his storytelling abilities. Doesn't make a difference, facts be damned. Facts don't really make a difference. We need to tell a story. What convinces the jury is a good story. What convinces a judge, likewise, is a good story. Many of these instances, the judge does not really care about facts. At least that's the way it seemed at this hearing that I was at. The judge had not even read the paperwork prior to the hearing beginning. I was shocked that he had to take time out and read part of it. There were many motions that were filed and evidence that was entered that he did not even address. There was a motion that was given to this judge to have an in-camera interview for a child who was over 12 years of age, who was an alleged abused victim of one of the parents, and the motion was also to make record of the same. So this person wanted the judge to interview the child with a camera and then also enter it into the court record. According to the Texas Family Code, in Provision A of Section 153.009, it says, in a non-jury trial or at a hearing on the application of a party, any party, a party, the court shall interview in chambers a child of 12 years of age or older. That's what it says. And it was very interesting because during this hearing that I was at, the judge made sure to let people know who was the party and who was a representative of the party. So the attorney was representative of the party, but the two parties themselves, the parents, were the parties. And so on the application of a party, the court shall interview in chambers a child 12 years of age or older. This was a motion given to the judge. The judge did not rule on the motion, did not consider the motion. That was where the neglect of the judge occurred, and his neglect turned into abuse. The father came and pursuant to the Texas Family Code, Title 5, Subtitle B, Chapter 153, Section 153.009, the father is asking the judge to enter an order requiring both parties to produce the minor child. He's well over 12 years of age. He was requesting an in-camera interview be included as part of the hearing that was given on August 22nd, 2019, upon all issues directly impacting his life and for a full record to be duly made of the same. The reason that he was asking for this interview is because further physical violence, abuse of my son is imminent without this court acting to protect him from, and the people are named. The father is alleging that his son is in danger, physical danger, suffering physical violence and abuse by the hands of the son's mother and the son's stepfather. I took a look at some of the other records. There were police records and there were medical records. There was the testimony of the son himself. The police records were very, very clear. The medical records were very, very clear. The son's testimony, you could tell, was written by a 14-year-old child. The affidavit had a little bit of help as far as the formatting of it, but nevertheless, it was the son's own words. The judge should have taken a look at these. The judge neglected to do so. The judge refused to do so. Whatever the case may be, the judge was negligent in his duties. And because the judge was negligent, it appears that he had to cover for himself, and he ended up abusing the litigant. But once again, he comes back to Section 153.009 of the Texas Family Code, which requires the court to provide, now he said in-camera interview of the minor child. I don't see in-camera in the Texas Family Code, but it should have been an in-chamber interview of the minor child, not only to determine the child's desires and wishes for primary residence and school and so forth, but also to determine if there has been any acts of violence by either parent upon any other matter relevant to the array of custody and modification factors in Texas law. Once again, the judge refused to even consider this in his court, to the best of my knowledge. I sat there throughout the whole thing. I never once heard the judge rule on this, bring it up, period. Judge Graham Quisenberry. And it is more than just a determination of proper residence and the custody that is of interest of the court, but also as well whether resolving the number and severity of child abuse crimes under Texas law by the petitioner and the husband should be considered. So this was not merely a family matter. It was not merely a civil matter. It becomes a criminal issue. But this judge, Judge Graham Quisenberry, did not look at the evidence, as far as I could tell. Again, I was sitting in the court for almost an hour and a half. I watched the entire thing. The judge was very abusive toward the father, but the judge did not even consider the evidence, it appears, that was submitted before him. Nor did he consider, as I recall, the motion for an in-chamber interview. In fact, during the course of the hearing, the father again asked the judge to conduct an interview with the son. And the son, by the way, was waiting outside the courtroom. The son was there. The court could have done its job. The judge could have done his job, could have ruled. But instead, the judge says, well, maybe what we should have is a psychological evaluation. And first, he addressed the mother and said, mother, would you be willing to do this? And the mother turns to the attorney, and how much is it going to cost? And, a couple $1,000s. And the mother says, yes. So that should have been the end of it there. But now the judge, in the interest of this great fairness that he has, says, well, father, do you want to chip in 50%? So, of course, here is the father filing on behalf of the son, filing on behalf of physical abuse and violence committed against his son, which the judge refuses to read. And now the judge is going to make things fair. Father, would you like to pay 50%? And then he turns around and adds one step further. Father, maybe you should pay the entire thing. The father says, well, that's not fair. But this is fairness, according to Judge Graham Quisenberry. Amazing, amazing. There were other abusive acts and threats conducted by Judge Quisenberry against the father. I'm not going to go into that here, but there were plenty. I was appalled. I was appalled that a judge who is supposed to be determining facts was abusing the father of the son because he was making these motions. So once again, the father had prayed for the court to enter an order according to the Texas Family Code, section 153.009, section A, that a judge shall, on the application of a party, the judge shall interview in chamber a child over the age of 12 years. The judge shall do this. The judge has a discretion. No, the judge shall do this, but this judge failed in his responsibilities miserably. So the video that I took of this son was basically to give the son a voice. The son has been pleading to meet with a judge. The son has written letters on his own behalf to be submitted to the court, and the court just ignores him. I asked him if he wanted to speak on camera, and he said yes. And it was interesting because after about 30 seconds, other people tried to break up the interview. It was a very peaceful interview. I just wanted to know what his perspective was. So somehow hearing from the child himself is a threat to this whole family law system, or family lawless system, or anti-family lawless system that this judge and other people are invested in. They make a lot of money doing it. Once again, the father wanted this. The mother did not. Why did the mother not want the testimony to come forward? Why did the mother's attorney keep on putting objections to the fact that, this child should be able to testify either in front of the court or with a judge? Why did he do that? Because he knew the evidence was damning to his client. Evidence, once again, which consisted of police records and medical records and the son's own pleadings for help. I know because I read them. Judge Graham Quisenberry, it would appear, did not. That is what takes place in these courts. If you are watching this, or if you know of a friend who's going to court, I'm going to encourage you. You have to go to courts. When people talk about what takes place in courts, you have no idea how bad it is unless you're there watching. No matter how they describe it, it does not adequately capture the abusiveness that often takes place in these courts. Thank you.
Don't need to be doing that.
I'm going to be going outside and doing that.
What's that?
I said I'm going to go outside and talk with him then. I was going to talk with him ahead of time because I figured this was going to happen because I've seen the way these courts have worked. It was atrocious what happened in there.
You're going to have a problem. I'm telling you.
Okay, that's fine.
I'm telling you.
That's okay. If that's what you say.